preliminary injunction of one very specific provision of that's in both executive orders. It's the provision that cuts the number of refugees who can be resettled in the United States this fiscal year from 110,000, which is what President Obama set it at in September, down to just 50,000. And so we have a motion pending to get that part of the executive order blocked, but we're also going to be filing a new motion tomorrow that where we're going to ask the judge to block the second executive order in its entirety. And we're, you know, like just as Hawaii's trying to do, we're going to ask the judge to block the new executive order before it goes into effect on March 16th. And so, you know, since Monday when the executive order came out, we've been, you know, pretty feverishly working to amend our lawsuit in Maryland to add claims against the new executive order, and also we've been, you know, working on our motion that we'll be filing tomorrow. I think by 5 o'clock Eastern. And, you know, we're going to be asking the judge to move pretty quickly there. And, you know, like we're going to say the government's opposition's due on Monday, and then our last brief would be due on Tuesday, and then, you know, there might be an argument in Maryland on Wednesday, so that it can be ruled on in advance of Thursday. So things are moving really fast right now, and I think it's, in the litigation in particular, I think that it's entirely possible that we'll see additional lawsuits filed in the next few days against either, you know, parts of the executive order or perhaps the whole thing. But, oh, and just to say a word about our claims, I mean, our principal claims in the case, our principal arguments are what you would expect, which is that the executive order, the second executive order, just like the first one, was intended to discriminate against Muslims, and you can't do that under our Constitution. It violates both the Establishment Clause of the First Amendment, which says that the government can't prefer one religion over another and can't denigrate one religion in particular. And it also violates the concept of equal protection, which in this case is protected by the Fifth Amendment. And the idea there is, again, you can't discriminate against people on the basis of their religion any more than you can discriminate against them on the basis of the color of their skin. And so that is that's what we're going to be arguing. You know, we think that it's as a factual matter crystal clear that the executive orders are intended to discriminate against Muslims. The biggest challenge in these cases is going to be that the federal courts traditionally defer to the president when it comes to matters of national security. And so the challenge here is to convince the court that deference in this instance is not appropriate in light of the overwhelming evidence that the executive orders are not actually intended to further national security, but are just meant to discriminate against Muslims. So
great.
Done. Yep.
Okay, thank you, Justin. So we are getting a couple of questions. This first one might be more for Avide or Alika. Are there recommended resource guides for families whose family members are affected by the new ban?
This is Avide, and Alika, please feel free to add. There are a lot of resources around sort of breaking down what this means, who it affects, based on what happened in the hours, days, and weeks since that first order. Some advisals that are also included in some of these resources, and just sort of steps that people might want to take. So we can certainly share those. I mean, we have our frequently asked question that we've updated, as of many other organizations. Alika, did you want to add any other specific resources that you all are using?
Sure. Yeah, I think maybe we can send around links, right, to the different advisories that are in English, Farsi, and Arabic. At least for the Bay Area, there are local organizations that have hotline numbers, right, if a family member is going to be impacted. So happy to send those to NILC as well. And, I think for a few other geographies, but there isn't a like a national hotline in that sense that I'm aware of.
I think the only other one I'm aware of, oh, sorry,
no, go ahead.
There's an email account that one of our clients, IRAP, is running. It's, I think it's airport@refugeerights.org. If folks have trouble in airports, please let them know. We've been working with IRAP and a law firm, and we have materials ready to go in the event that people are detained at airports, and and there needs to be a lawsuit, a habeas lawsuit, like we filed in Darwish in the Brooklyn case. We have resources in place to try to help folks who need it. So please reach out to that.
It is, though, airport specific. So there are separate numbers for San Francisco and LAX, right? And different folks that are on the ground in that respect. That's coordinated through One Justice. So that's another great way to get in touch with individuals who are actually physically at the airports.
All right, thank you. And there's another question, I think, for any of the three of you to answer. Is it likely that this executive order will be expanded to other majority Muslim countries?
This is Abida. I'll just quickly and allow others to add. I mean, I think obviously the wave of lawsuits challenging the first one caused the administration to backpedal and revisit its, unconstitutional idea in the first place. So I think that part of what we may see is the combination of both public response as well as the response in the courts. To some degree, the administration, not just with this executive order, but with all of the immigration-related, refugee-related executive orders, is sort of testing the limits of what it is able to do with impunity versus when the public is really pushing to hold it accountable. So I think that remains to be seen. I'm not aware of anything imminent, but I think the fact that there is this, I think that part of what DHS is trying to do is perhaps provide some cover against the idea that they're going after exclusively or only Muslim majority countries by saying, and at least giving some lip service to the notion that perhaps some other non-Muslim majority countries could be added. But it's vague, and I think it's intentionally so.
Yeah, this is Alika. I would just add that in past discriminatory immigration programs that impacted the Muslim community, like the National Security Entry Exit Registration System and SEERS, that was active, I believe, from about 2002 or 3 to 2011 or 2012. It had a similar model in place in that it started out with a set of countries and was expanded out over time to up to 25. So I think when we look at the history of discriminatory immigration laws for these communities and this type of national origin and religious-based discrimination, there's definitely a history of expanding out, but definitely echo and agree with what Avida flagged.
All right, thank you, three. So I think now we'll move on to other enforcement issues and how they intersect with DACA issues. So our first speaker is Emilio, who is from United We Dream. Emilio?
Thank you, and thank you for putting all of this together. Like everything that all of you have talked about, immigration, the issues of undocumented youth, immigrants, and the Muslim ban, we stand in solidarity first and foremost because we know that this is all attacks on our communities, and we stand in solidarity. So I'm here to talk about what's been going on immigration during the last few month and a half. What we've been seeing so far is that while we know that deportations rates are nothing new, what we have seen is more reports of immigration being emboldened and going after people who shouldn't be priorities in the first place. And maybe many of you have heard of the case of Guadalupe Garcia de Rayos in Arizona, who was following direction by immigration officials of going once a year, doing a check-in. She was going onto her 8th check-in this past month, and they detained her there, and she was unfortunately deported within 24 hours. There was a lot of outrage, rightly so, from the community, saying that she shouldn't have been a priority, that it made no sense that she would have been detained, especially as a mother, somebody who's contributed to her community, and activists tried stopping her deportation by blocking the bus that she was on. Again, unfortunately, she was still deported. So again, this isn't an isolated case. We've seen other cases that are similar of, again, people who shouldn't be priorities for immigration enforcement being targeted. Can you go to the next slide? And so I know that NILC has already done a webinar on the executive orders and the recent memos by the Department of Homeland Security. I'm just going to quickly go over them because I think that they're relevant to how immigration is playing out right now across the country. So again, as we know, ICE is feeling more emboldened than ever before to target people who, again, shouldn't be priorities for deportation. As you all probably know by now, there's a big emphasis on the construction of a border, specifically on the south between Mexico and the U.S. We've also seen reintroduction of secure communities, a program that was phased out during the Obama administration. Secure communities being a program that essentially allows police enforcement to scan the fingerprints of people that they've arrested through an immigration database, and if that person is a match with immigration, that person is put on a detainer, and essentially that's how a lot of people have been deported in the past. We've also seen further promotion of 287G. 287G is essentially a program, again, for further collaboration between local enforcement and immigration officials. In this case, local enforcement essentially is doing the work of immigration agents. We've also seen continued attacks on sanctuary cities being places that have either publicly said that they will in some way, shape, or form not collaborate with immigration enforcement, either publicly or through other means. And we've also seen the punishment of people who have sent for their family members to be able to reunite within the U.S. And so all of this is to say that publicly we have these memos, executive orders on one hand, and then on the other hand, the Trump administration, specifically President Trump, has been very used rhetoric of I'm very sympathetic towards undocumented youth, of I support undocumented youth, and as somebody myself who is undocumented and fits and is a youth, and a lot of our members in United We Dream, we don't accept that and we don't believe that because we're unwilling to be used as pawns as these executive orders and memos are implemented. And again, we also know that Trump probably doesn't mean what he's saying because of two specific cases of undocumented youth who've been detained and are currently fighting their deportation. So if you go into the next slide, I can talk more about both of the specific cases. And so the first person who was detained and who again has had deferred action was Daniel Ramirez Medina. I'm assuming that some of you heard about him, about his case. He's from Washington State, and he was detained when immigration officials raided his house early in the morning. And amongst the reasons that they gave for why he was detained, even though he had deferred action, was because they said that he was in a gang simply because they misinterpreted a tattoo that he had and assumed that it was a gang tattoo. We also have proof that immigration officials have doctored documents about his case, and basically saying that he admitted to being in a gang. He says that he didn't do that, and again, we're seeing this emboldenment of immigration officials trying to get away and make excuses for why they're detaining people. And through all of this, he said he's unfortunately had his deferred action revoked. And we wanted to point out that he has a three-year-old son that he has made a life in the U.S. as well. And today is actually his 24th birthday. So if you pause and think about it for a second, I don't know about you, but I know that I probably wouldn't want to be in a detention center during my birthday, especially 24th birthday. And so if you're on social media today, we encourage you to use the hashtag #FreeDaniel and send him a happy birthday wish. And we are supporting his case, and we hope that he will be let out soon enough. Can you go to the next slide? The other case of an undocumented youth being detained is of Daniela Vargas. Again, it's another case that made national headlines last week. Daniela was detained while she was speaking at a press conference. She was in the process of renewing her deferred action. And again, immigration raided her house, and she didn't feel safe enough and was going to go into hiding after this press conference. And she was detained as she was leaving. And again, we're seeing this emboldenment of ICE trying to push the limits and boundaries of what we see as very concerning actions, especially as she was speaking at a press conference. Clearly, it was a violation of First Amendment rights. On our end, in support of both of these cases, we launched petitions. Last Friday, we delivered almost 50,000 petitions to the headquarters of ICE. They didn't let us in. They wouldn't accept our petitions, but we were outside calling on them to stop these unjust raids and to stop the deportation proceedings of Daniela and Daniel and to release them as well. And so I think if you go to the next slide. So some of the things that, so now that you've heard more of like what's been going on more recently on immigration, you might be asking yourself, what can I do? So here at United We Dream, we have our Migra Watch hotline, and I think most of you can see the screen with the number. We're using this hotline to track the potential raids in a specific area. I know that we've seen a very significant increase of how many calls we've been getting per day. Again, over the last month and a half, especially with a lot of activity going on across the country. We encourage all of you to text Here to Stay to 877-877 to keep informed of what's going on in your area. And especially to our allies, we're calling on you to help us and to join our Here to Stay network. We created this network because as we know, these raids are not going to stop anytime soon, and we know that when we fight back, we are strongest. And those especially who have documentation can especially be helpful in this, as people might be afraid, and at some point we might call on you to help stop the deportation of somebody who is local to your area. So again, thank you for having me on.
Thank you, Emilio. And Justin's going to join us again to talk about the lawsuit that we filed for Danny.
Sure. So on this past Monday, I guess it was, NILC, along with the Southern Poverty Law Center and with Danny's immigration attorney, who's based in Mississippi, we filed what's called a habeas petition that's in a federal district court in Louisiana, asking that Danny be released. So she's currently in a detention facility in Gina, Louisiana, and so we had to file the petition in the district court there, and in the petition, we argue two principal things. First, as you just heard, the arrest of Danny was clearly in retaliation for her exercising her First Amendment rights, and even undocumented individuals have constitutional rights in this country, as I'm sure you all know, including First Amendment rights. And so, we pointed out that the facts really are quite clear here. On February 15th, when Danny's home was raided and her father and brother were arrested, the ICE agents, they knew that day that Danny's DACA had expired, but they nonetheless told her that they were giving her a hall pass, that they were, cutting her some slack. But then over the next couple of weeks, she spoke out to the media about just how terrifying it was to have her home raided and to see her father, walked out in handcuffs, and to not even be able to say goodbye to her brother. And on March 1st, there was this press conference that was at the City Hall in Jackson, at which she spoke, and then, she was driving away from the press conference and had been driving for fewer than 5 minutes when she was pulled over, and one of the same officers who had been at her house 2 weeks earlier, walked up. She was in the passenger side of the car. He walked directly to the passenger side of the car and said, "Daniela Vargas, remember me? You're under arrest because you're an illegal alien." And so they arrested her. And the other part of this case that's really infuriating is that they are seeking to deport Danny without letting her see an immigration judge. So there's a program called the Visa Waiver Program. Some of you may be familiar with, but it allows nationals from certain countries to enter the United States for tourist reasons, typically, without having to get a visa in advance. And in 2001, when Danny and her family came here from Argentina, Argentina was part of the Visa Waiver Program. And one of the conditions of entering through the Visa Waiver Program is that you waive your right to see an immigration judge if you're ever found to be deportable by an immigration official. But the problem here is that ICE is saying that Danny waived her right to see an immigration judge when she was 7 years old. 7-year-olds can't do multiplication. They certainly can't understand what it means to waive their constitutional right to see an immigration judge in the event that 15 years later ICE wants to retaliate against them for exercising their First Amendment rights. And so, our second argument in the habeas lawsuit is that this alleged waiver that ICE says Danny executed when she was 7 years old cannot be valid, is not and cannot be valid, because a 7-year-old does not have the capacity to waive constitutional rights. Just like a 7-year-old can't enter into a contract, they can't waive rights in this fashion. So we also filed an emergency motion for an order preventing the federal government from deporting Dani while that lawsuit is pending. That motion is still pending as well. We hope to get an order very, very soon from the district court judge, but it's the South and things don't always move that fast down here. So we don't have a great idea of what the timing is, but and in the interim, we're exploring other ways to try to protect Dani from deportation. That's our most immediate concern, is to make sure she's not deported. And then once we sort of have some assurances there, we'll be exploring the various options to get her removal order vacated and to hopefully try to get her to, at the very least, to a point where her DACA is renewed, because as was mentioned, she has her application to renew her DACA was filed on February 10th, and so assuming DACA is still around in a couple months, hopefully her renewal will come through, and so at the very least, we're hoping to keep her here that long so that she can have DACA once more and have some modicum of protection.
All right, thank you, Justin and Emilio. And if the news wasn't already grim enough around the changes that we know are happening, Matt's now going to talk about what we've been hearing in terms of a potential executive order around public charge and public benefits issues. So Matt?
Thanks, Xiuming. Okay, so I'm going to talk a little bit about, as Xiuming says, a draft executive order that was leaked a bit in early February. So I'm going to start with a little bit of where we're at now. I want to start by saying that where we're at now is that nothing has changed as of now. Public charge determinations are still based on the 1999 guidance that folks might be familiar with or have been living with for almost 20 years, which is really just a way that a codification of what the policy had been before. So it's important to know that to start. The leaked EO that people may have seen has not been signed. If and when it were to be signed, that final version could have big changes and would likely, parts of it would likely be subject to the writing of regulations. So if things were to change, it would be one, we would need to wait until we saw what the final wording is, and then even after that, we may not know exactly what everything means. So just to let folks know out there that we're still kind of at the same place that we were operating at before. So one thing that we've been talking a lot about at NILC is trying to focus a lot on thinking about what we do know and then thinking about what we don't know so that people can make informed decisions for themselves. What we do know is that the existing public charge rules. So public charge is, for those who aren't too familiar with the subject, public charge is a ground for inadmissibility to enter into the country or to get one's green card. It is intended to limit people who would become, as the law says, kind of dependent on government assistance. So previously, this has been pretty limited to cash assistance, so like welfare, and to long-term care in like a nursing home. So those are two pretty narrow ways in which it has applied before. It's also important to know what public charge is not. It does have some limits. There are certain groups, people like refugees, asylees, domestic violence victims, and others that are excluded from a public charge determination. It's also helpful to think about this being only part of a determination. The public charge determination is what lawyers call a totality of the circumstances, which means that the person making the decision has to look at a bunch of different factors, things like age, someone's job, someone's earning potential, and it's also forward-looking. So it's looking at whether the person is going to, in the future, be a public charge. So, and even if there is something that the government might consider negative, that can be overcome with other factors. It's also helpful to think that think of where how this is narrowed. It only applies at entry or re-entry and when somebody is seeking a green card. It's not something that arises at the point of somebody attempting to naturalize. So it's not something that has to be continually all the way up to naturalization. There's also been a bit of talk and a bit of concern about whether this could be something that could lead to deportations. Deportation based on public charge is a very narrow test, so narrow that it's only really been used a handful of times in like 100 years. So it's not something that is an immediate threat as one of the most likely possibilities of there being increased enforcement. The leaked public charge wouldn't be able to change a lot of what I just discussed. What it would do is it would say that there would be more programs that would be part of the public charge determination, but then again, they would still only be part of that determination. Other things could be factored in as well. It would also make it so that that additional programs are subject to sponsor liability, so a sponsor could be liable for more under those rules. And it would restrict the child tax credit to only people who have Social Security numbers. Those are some of the main points of the public charge determination, or the public charge leaked executive order. What is helpful looking forward to think about is what we need to do to prepare. So although it's helpful to think about what this public charge issue is not, we definitely know that this is the way that this administration wants to pursue an anti-immigrant restrictionist agenda. We expect to see these kinds of issues arise, even if this weren't to be released, that we need to be aware of. So it's good to get information out to communities so people know their rights. One thing that you all can do is help us to document the harm. It could easily be that the threats and the fear could end up causing more harm than the actual policy changes. We're already seeing evidence of that before any policy change has actually been made. On your screens right now, there's an email address, publiccharge@nilc.org, that you can use to reach out to us to let us know questions that people have so we can prepare materials, and also instances of harm that may arise. Also, it may be helpful to be active in your community and arm them with information like we're discussing today so that they can make their own informed decisions. There may, for instance, be no actual advantage to disenrolling now. People would have to put the fact that they had used such programs on their application already. It also may be important and highly advantageous for people to receive the health care and the other supports they may need to live healthy and strong lives and to be productive in their community. Every person really has their own decision to make, and it's all about trying to help folks make those decisions. If you go to the next slide, I just have a couple quick points I want to make about some other executive order issues that are somewhat related. There are references in a couple other executive orders. The enforcement priorities, a memo that implements those came out this week that caused some concern. It referenced, quote, abuse of benefits programs. A later Q&A that the Department of Homeland Security issued, it made clear what we would have argued anyways, which is that is actually a pretty narrow situation. It's limited to knowingly defrauding the government. It has to do with like making a misrepresentation, false information to the government. So Generally, this is not the same thing as public charge, and it does not mean that the legitimate use of a program for which someone is eligible would make someone a priority for enforcement. This is consistent with advice that we've generally given to avoid fraudulent application materials, because that can just have ramifications elsewhere. There's also very quickly, the Privacy Act reference, which states that only people who are citizens, nationals, or lawful permanent residents will be subject to protections under the Privacy Act. Well, for one, this is actually what the law says, although not how it's generally been enforced. And this could have ramifications in other areas, particularly in people accessing and changing information. And there are some concerns that other organizations are focusing on. From a benefit standpoint, I just want to reiterate to folks that there are other protections within each of the individual programs, such as Medicaid, such as the nutrition assistance, that protect folks. So it's important to know that we can enforce other privacy protections, both at the federal level and at state offices, to ensure that people can use these programs. And there's a blog post there that goes into some of these issues that I encourage folks to check out.
All right, thank you, Matt. So we're getting a lot of questions. The first one goes to you, Emilio. It says, what can DACA recipients do regarding their own safety?
Yeah, so first and foremost, we encourage all of you to know your rights, including what to do if you ever come in contact with immigration officials. If you go to the United We Dream web page, you can get more information on the different steps that you can take, again, to be prepared. We also encourage you, if you're already in the procedures with DACA, to make sure that you're up to date with that. Again, we are in an uncertain period, and we don't know if the program will be revoked. But as we continue working around DACA, we want to make sure that everyone has the right information, and we also encourage everyone to be involved. Again, I know that this is a very scary period for many of us, myself included, but we've seen again and again that the more people speak out and the more that they humanize this issue, the more likely that there will be a big community behind you to support you in case of anything.
Thanks. And there's a question for you, Matt. It says, do you believe there's something we can do now at the state level, such as passing a law to limit the impacts that the leaked EO on public charge might have?
I think that folks can be in contact with their government to see what they can do to ensure that their government is following all of the privacy protections that do exist. As far as existing laws, that's something that we've been thinking a bit about, and I encourage folks to stay in touch with it. You're welcome to reach out to me individually if you're interested in this. In pursuing a policy like that, we haven't quite figured out exactly what that option could be, but that is something that can be thought of, and certainly engaging and getting support from state legislators or local city council members is a good way to push back on this.
All right, thanks. And there's a question, I think either for Emilio or maybe Avide, around can ICE conduct raids at a public library?
Avide, do you want to take that one?
Sure, and feel free to add. So ICE has had since 2011 a policy in place that it refers to as its sensitive locations memo, and basically it outlines particular areas where, essentially for reasons of in the public's interest, they try to avoid any enforcement activities, raids, arrests, other things in those particular areas. And it specifically lists schools and hospitals and places of worship or certain religious ceremonies, as well as I'm sorry, I totally just drew a momentary blank. As well as I think I said schools, hospitals. Jump in if I'm
places of worship.
Protests, yes. Peaceful protests, yes, where people are exercising their First Amendment rights. And it doesn't, you know, again, the idea is that having enforcement activities there can have a real chilling effect on the community, and that was the intention behind putting together the sensitive locations memo. It doesn't explicitly reference libraries, but libraries, to the extent that they might be connected to a university campus or a school or other educational community, you know, it could potentially fit into the definition of a sensitive location. I note all that because even though there were massive changes and a rescission of a lot of pre-existing policies, ICE continues, despite what it has done, in flagrant violation of this memo. It continues to say that that memo is in place. They will say, they have said that, you know, if it's just outside of the premises of these quote-unquote sensitive locations, and that is fair game. But as you know, some of you may know, there have been examples, high-profile examples, for example, of a domestic violence survivor who was seeking an order of protection in a court in El Paso, Texas, and ICE arrested her in the courthouse and then tried to cover it up. So I think there are quite legitimately questions around even places that do fall within the sensitive locations. Again, depending on where the library is, it probably would not fall in the strict definition of sensitive locations, but it again depends if it's on a campus or a school community.
Thanks. And we have just one last question for Matt, which is, could the public charge issues, could they be applied retroactively to the past use of public benefits?
We are looking into the legal ramifications of what exactly the limits would be on what the government could do. I don't have enough of the research done to be able to give a definitive answer on that right now. We will be sure to try to get that answer out to folks as soon as we have an answer from some lawyers that are helping with us on that.
All right, thank you. So thank you to all the presenters and also for the attendees for submitting your questions and for participating. And we will email you a copy of the recording as well as a copy of the PowerPoint either tomorrow or Monday. And we look forward to having you join future webinars. So thank you.